afternoon. Thanks everybody for being back promptly. Good afternoon, Mr. Barrows.
Good afternoon.
It is morning somewhere. Well, when you get settled and comfortable, you may begin with your opening statement.
I think I'm ready. Thank
you.
First of all, I want to thank you, Ms. Roberts, and members of the Commission for serving in this capacity. You've given considerable time and energy to this very important task. Your efforts are essential to ensure that Iowa has a fair and independent judiciary. A little bit about me. I'm proud to be a small-town Iowan, raised by small-town Iowans. I grew up in Follett and Comanche, both in Clinton County. Most of my family still lives in that area, and I currently serve as the Clinton County Liaison Judge. My parents were children of the Depression who worked hard and eventually built a successful family business. I am the first in my family to go to college, conscious of the sacrifices of those who made that possible. All of this informs my character and fuels my work ethic. If fortunate enough to be appointed, I hope to take what I have learned to the Iowa Supreme Court. I'm married. My wife Karen is an attorney for the United States Army. I have two children, Ellie, age 12, and Max, age 10, who, of course, are the inspiration for much of what I do and hope to accomplish. Of course, there are two questions most asked when one applies for this position. Why do you want the job, and how would your appointment enhance the court? I'll address both of those. My reasons for applying are to deal with the important and cutting-edge issues that come before the court. I think that is something that appeals to almost all of us who do this work. In my case, that would be particularly true of the cyber and electronic evidence issues that loom on the court's horizon, both in the civil and criminal contexts. To work toward improving the system of justice on a statewide basis, including access to justice issues, I believe that a district court judge's experience dealing with pro se litigants is particularly critical on this point. To advocate for specialty courts, a cost-effective and humane way to deal with many nonviolent offenders whose crimes are driven by addiction and/or mental illness. It is, of course, the Supreme Court that administers the district courts. It's my strong belief that the court needs additional members with district court experience to more effectively do so. With Justice Cady's untimely passing, the court is now down to only 2 members with any district court experience. And on a more personal level, to make my family proud and to set an example for my children, showing them what is possible through hard work and determination. Now, I think what's probably most important to you, the question, how would my appointment enhance the court? First of all, I just want to state that we have a Supreme Court comprised of exceptionally gifted individuals who are obviously capable of figuring out most things on their own. I simply look at the collective knowledge base of the court to see where there are areas in which I might be of assistance. Nobody has experience with everything, particularly in this age of specialization. My belief is that the court should work together in a collegial fashion, drawing on the varied backgrounds of the members, and these are the areas in which I think that I could help. I have handled cases of considerable complexity, including numerous sophisticated criminal prosecutions in the challenging environment of federal court. I do believe that the Supreme Court could benefit from the perspective of someone with this type of extensive criminal experience. After all, an enormous percentage of their caseload consists of direct criminal appeals and post-conviction relief actions dealing with criminal law issues. At present, there is limited criminal experience among the members of the court. I was both the computer hacking and intellectual property, or CHIP, coordinator and Project Safe Childhood coordinator for the Southern District of Iowa. This afforded me the opportunity to become trained in and experienced with cutting-edge issues of electronic evidence and computer forensics, including the complicated topic of privacy in the age of the internet. In both capacities, I received specialized and sophisticated training at the National Advocacy Center in Columbia, South Carolina, as well as at numerous additional conferences around the country. To give you an idea, the CHIP coordinators were the individuals in the various United States attorneys' offices who were responsible for the nation's most complex cases in areas such as cyber intrusion and DDoS attacks. They also grappled with exceptionally challenging issues involving electronic evidence, including its acquisition and use. I personally have litigated numerous cases that involve the introduction of complicated computer-based evidence, including the digital trail that evidence left as it bounced around servers in the United States and sometimes around the globe. This training and experience would be valuable to the court as it continues to grapple with these issues. Just a few examples of what the court might confront in these areas would be the following. What metadata is covered by the discovery process? What tracking data will require a warrant? What is the reasonable expectation of privacy and the wide variety of digital information shared with or otherwise provided to app developers or social media platforms? What type of process is required to secure these various types of information? What is the evidentiary value of data found in the unallocated space of a computer? What foundation is necessary to admit this type of evidence? And what about biometric data? At what point, if any, is this considered testimonial evidence? These are just a few examples of the dozens of such issues that the court will face. This is not to suggest that I would come to the court claiming to have all of the answers to these questions. Not at all. I simply suggest that at present, I see no one on the court with this type of experience. Given that, I believe my training and experience would be particularly helpful to the court as a group in understanding these issues. I have been the drug court judge in the 7th Judicial District, with my rotation ending this past January. This has been a profound experience that has given me insight into the challenges faced by those in our criminal justice system who struggle to break the grip of addiction as they attempt to rehabilitate their lives. This has informed me as a district court judge and would continue to do so if I were fortunate enough to be appointed to the Supreme Court. Additionally, the state has recently received a federal grant to aid the judicial branch in its support and assessment of drug court programs. I am not aware that any member of the court has supervised one of these courts. As such, I think my experience in this area could be particularly beneficial. My experience as a writer, appellate advocate, and judge has given me the ability to craft opinions in a useful, clear, and concise manner. I think this is tremendously important to making the court's rulings more accessible and helpful to the public, practitioners, and judges. I've never been on the 60-day list. If that time frame were shortened to a 10-day list, I would still never be on that list. In fact, a few weeks is the longest it ever took me to produce a decision, and that was after a week-long bench trial involving numerous complex business and employment law issues. I normally have my decisions out in 1 or 2 days. I know that my chief judge and district court administrator would both tell you that I am one of the most efficient individuals in the 7th Judicial District, always willing to cover another county on short notice, and willing to fill in on cases when someone calls in sick or has a conflict. I routinely work the queue on my own to help the administrative judge or take other random assignments to help my colleagues, and I believe that is what they would tell you. Finally, I believe that I have demonstrated a patient, thoughtful, judicial temperament while on the bench, a strong work ethic, and a firm grasp of the issues. I make certain that the litigants have been heard and that they feel they have been heard. My many and varied life experiences leave me quite conscious of the frailty of the human condition. I have an appreciation for people from all walks of life, and that is something that I would hope to bring to the Iowa Supreme Court. Thank you for your consideration.
Thank you, Judge Barrows. We do have some questions at this time, and we will begin with Mr. Hoyntink.
Thank you. Good afternoon.
Good afternoon.
We've heard from a few candidates today really emphasizing criminal law experience as something perhaps needed or lacking or an opportunity for improvement for this court. A couple of different spins on that have been whether that's prosecutorial or defense. Can you speak at all to your viewpoint on that?
Well, I think both are important, certainly. I was a prosecutor for 18 years, both in the state and federal systems, so obviously I was completely immersed in that world. And as you know yourself, Mr. Hoytink, having been an assistant U.S. attorney, those issues dealt with in the federal court system are extraordinarily complex and are really the cutting-edge issues in the field in the United States. And that's why I think that experience in particular in the federal system sort of uniquely situates me to help the court confront the complicated criminal issues that are coming down the pike.
Thank you.
Ms. Valentine?
Thank you. We probably all want to ask you questions about cybercrime, but I'm guessing that you would probably have to kill us if you told us. So I'm going to go back to your application where you talk about, where did it go? Now I just lost it.
Is it the cybercrime?
Well, see, I got excited about that. Your broad experience as a litigator, appellate advocate, and judge, and I'd like you to talk about each of those roles briefly and how each of those roles would help you on the court.
Well, obviously the Supreme Court is reviewing what happens in our trial courts. I mean, that's where the rubber hits the road. That's where most individuals have their interaction with the court system. So in that regard, I think being a litigator is particularly important to anyone who would sit on this bench. You have to know what happens in the district court to, one, I think, more effectively assess the cases that come before you, but most assuredly to help administer those cases. With respect to being an appellate advocate, the importance of that, of course, is obvious. You develop an appreciation for the role of what the advocate confronts when they come before you, as well as what the court needs to decide in that situation. And I'm sorry, I can't remember what the third one was.
The third one was judge.
Oh, well, obviously wearing the robe is important, I think, in large part to see if it's an individual who would be appropriate for a role with this much responsibility. I think there's really no way to test how a person will react to wearing the robe and the authority that comes with it more than wearing the robe itself. A lot of you are practitioners, and you've encountered the situations where there has been someone that you thought would be an outstanding judicial candidate who was appointed and then developed what I call black robitis. None of us want to see that. You certainly don't want to see it here. What we want here is humility, patience, listening, and things that appropriately represent, I think, what Iowa is about.
Thank you.
Mr. Sukup?
Good afternoon, Judge.
Good afternoon, Mr. Sukup.
In some of our past visits, you talked that you really enjoy writing, and that actually outside of work you do writing as well. Wondered if you had any current projects going.
I always have a current project going. Yeah, actually, I just finished my fifth novel, and it's going to the publisher pretty soon, so thanks for asking.
Okay.
Ms. O'Brien?
No questions, thank you.
Mr. Berger?
No questions.
Ms. Conover?
Judge, the suggestion has been put out there, and you've talked about it a little bit, that we need more district court experience up here on the Supreme Court. Have you given thought to specifics from the administrative perspective of the Supreme Court, of if you were given the opportunity to serve on the Supreme Court, practical things that the Supreme Court could do to better support our district courts?
Well, having been on the bench for going on 8 years now and having attended innumerable judicial conferences, I probably have more ideas than you would care to hear about. I think the one I've alluded to here and that I've discussed the most involve access to justice issues, particularly with respect to pro se litigants. As a district court judge, and I think this experience is really important, You know, I sit and deal with these folks every day, and they come in, normally it's in a divorce context, and they really struggle. They struggle with the forms, they struggle with the instructions. And I will say that from where we were 5-10 years ago, the court has taken enormous strides forward, I think mostly due to Chief Justice Cady. But we still have a long ways to go. As I deal with these folks, they have a hard time with these instructions that are still somewhat legalistic. We need to do more to simplify the process for them. I think that we also need to do a lot more to encourage what he referred to as a la carte legal services, to get attorneys to at least do some piecemeal legal work for these folks. When they divide a pension, for example, and have to do a qualified domestic relations order, that's almost beyond my capacity. It's certainly beyond their capacity in most instances. They struggle with the child support guidelines and numerous other things, you know, aside from just not knowing the law on the division of property. So I think that's one particular area for me. I think I could spend the rest of the time here talking about those types of issues, but I think that's the one that probably leaps to mind the most.
Ms. Pearson?
Thank you. Tell us what thoughts or ideas you have as to how the Supreme Court could enhance through outreach, educational opportunities, out to educate the community and, build trust for the average citizen and just a better understanding.
Yeah, I think Justice Cady did a lot in that regard. Certainly, I think taking the court on the road was a hugely important step to meet the citizens and members of the bar in the various communities that he went to. I think any time that you're going out and doing speaking engagements, it's important to help people's understanding of the court. What I particularly enjoy, and I did this addressing my daughter's 5th grade class to talk about the Bill of Rights, but I think going into educational institutions, particularly our public schools, to address school kids, to give them an appreciation for the process is something that's hugely important, because that knowledge of our system and respect for the rule of law needs to start there.
Thank you.
Mr. Gray?
Thank you. Judge Barrows, one of our candidates this morning suggested that geographic diversity is important for our judicial Supreme Court justices. First, do you agree? And second, what's your thoughts on whether you would add to the geographic diversity?
Well, in general, I think that you should pick the best person for the job. I certainly understand the desire for some geographic diversity, particularly in metropolitan versus rural representation on the court, because you do engage in a somewhat different type of practice in those settings, and you hear somewhat different cases on the bench. Now, that said, 90% of what you hear is still criminal law and divorces or paternity actions. So I think there's some merit to that. Generally, I think you should pick the best person. For me personally, I come from Clinton County, and I'm not aware that Clinton County has had anyone appointed to an appellate position in my memory. I cannot think of an individual. Ms. O'Brien might know, but I cannot think of anyone in recent history. So it's a consideration.
And are you suggesting that if you were put on the Supreme Court, your office would not be in Scott County but would be in Clinton County?
Well, I don't want to put the horse before the cart, obviously. If I'm fortunate enough to be in that position, it's my plan actually to put chambers in Clinton County. One, they have the space. It's questionable whether Scott County does, but as a son of Clinton County, I think it would be important for the county. I think the bar in Clinton County would be particularly appreciative of
Thank
that.
you. Thank you.
Ms. Law?
No questions.
Mr. Bevel?
No questions.
Mrs. Sinclair?
No questions.
Mr. Goodman?
Your Honor, a number of applicants have touted their criminal experience, and you've had substantial criminal experience. I'm wondering, is there a case that you have read from the Supreme Court where you have thought to yourself, if I'd been on the court or someone with criminal experience, the outcome would have been different, or we could have made that opinion more instructive and useful? Because I've heard from some applicants many times, these opinions come down and say, you did this wrong, but they don't tell you how to do it right or what you should have done.
I believe I've made that comment myself.
And Judge, I must ask you to be brief.
All right. I want to be careful with that, obviously, Mr. Goodman, because I wouldn't want to indicate how I might rule on a particular case. I guess what I would say about that is, yes, I have seen some instances where cases have come down and the district court has been frustrated by a lack of guidance. The most recent example of that would have to do with restitution, where, and I understand the court was just interpreting what the statute says, and the statute was a little bit problematic in that area, but it really gave us no guidance, and it has been extremely difficult to implement that decision for the district courts across the state.
Thank you very much.
Thank you. I do apologize that we're out of time. I think there are more questions, but unfortunately we don't have the time today. But thank you for being here. Thank you for applying, and we wish you well.
Thank you very much.
Thank you, Your Honor.